Hello, everyone. Welcome to the Week 7 topic on other alternative dispute resolution processes. In the previous 6 weeks, we focused our discussion on the mainstream and most common alternative dispute resolution processes. We focused, for example, on negotiation in week 2, and then we talked about mediation, we talked about arbitration, and then we talked about conciliation. So that's mediation, negotiation, mediation, arbitration, and conciliation. And we should observe, however, that although these particular ADR processes, which are pretty common and quite popular in use in order to resolve disputes outside of the court system, are pretty common, they're not necessarily always effective. And depending on the context or setting of a dispute, it is often the case that there is a need for other ways by which disputes may be resolved. And this has led to a lot of practitioners to consider other ways by which disputes may be resolved. And so given the limitations of the mainstream ADR processes, there have evolved more innovative ADR processes, which on the one hand can mean that there might be a shift in the way that lawyers view their roles in trying to resolve a dispute, such as when we talk about collaborative lawyering or collaborative partnerships. And we also examine other ADR processes that are typically useful in the context, for example, of the building and construction industry. And we're also going to be exploring questions of dispute resolution processes, which have seeped into the criminal justice system. And so the whole point is that although it's pretty common to speak of negotiation, mediation, arbitration, and conciliation as ADR processes, there are a lot of other ADR processes out there. But I won't be able to cover all of them because of the limited time, but I will focus on 8 other ADR processes in this particular lecture video. So on completing this topic, you should be able to discuss and explain several additional ADR processes. In particular, we'll examine collaborative law and restorative justice and other ADR processes, obviously, as well as any relevant theory, decided law, and or practical skills relating to ADR practitioners. So in particular, in this lecture video, I'm going to be talking about collaborative law and practice, case appraisal, expert determination, expert neutral evaluation, adjudication, court-appointed referee, and then restorative justice. And in giving this lecture, what I'm going to do is to try to pinpoint the advantages and disadvantages of any of these ADR processes. I shall also try to highlight the role of the third-party neutral, if that is the case. I shall also examine the involvement of the parties, as well as in certain cases, the role of the courts. So we're going to be looking at these 8 other ADR processes. So let's begin with the collaborative practice. Let's begin with the idea that when you have a lawyer, what the lawyer apparently does, given the training of the lawyer, is to immediately adopt an adversarial and legalistic position. So the lawyer knows the law, and lawyers have been trained to represent their clients. So typically, what lawyers then do is that when they represent a client, their approach is to try to win a dispute in favor of the client. It's not common for lawyers to be thinking of the other side. In fact, lawyers are not meant to do that, because that can typically represent a conflict of interest. In other words, a lawyer can't be representing 2 clients. So for example, when you speak of mediation, for example, in the early days of mediation, one of the most well-known mediators, and the reason why mediation effectively became mainstream in the US in the early 1970s, was that one of the main mediators was approached by a couple who were thinking of divorcing each other. And they came to this particular lawyer because they wanted to discuss how to amicably separate and discuss issues about children, and discuss issues about financial matters, and so on. So they came to a lawyer, and you would think that that is what most people would do. If you're a couple, you'd probably visit a person who could help out and give advice. But when you consider it strongly, there is an ethical issue there, because a lawyer can't be the lawyer for both parties, especially if they are in dispute. So in this particular case, what the mediator then said was that I cannot be giving you legal advice in relation to your problem, because that represents conflict of interest. But eventually what had happened was that, and this was the reason why mediation became mainstream in the 1970s, is that this particular lawyer, forgot his name now, but this particular lawyer then suggested that perhaps if we don't focus on the law, but rather we focus on trying to talk about your dispute and what the underlying issues might be, then we can move forward. So in that case, although he was a lawyer, he wasn't really taking on the role of a lawyer and using his lawyer's hat, but just him being there as an intermediary to try to get the parties to talk. And that was actually the beginning in the US of mediation practice. So we do know that although in general, and even today, it's pretty common to think of a lawyer as representing a single client, and a lawyer never tries to consider the interests of both parties who are in a dispute, given the issue of conflict of interest. One of the things that have emerged in collaborative practice, for example, is for these collaborative lawyers to think in terms of the respective interests and legal interests of both disputants, of both parties, or of all the parties in a dispute. And so in the collaborative practice approach, the role of parties and lawyers is to focus and on a negotiation and settlement rather than litigation. So they want to settle the dispute, they want to avoid litigation, they want to avoid going to court. And in order to do that, what the lawyers do, the lawyers of both parties, is not really to think of themselves in terms of I am the lawyer of the plaintiff or the lawyer of the applicant, but I am a lawyer helping my client to try to reach a settlement with the other party. It is collaborative because the lawyer has to go beyond thinking of just the interests of his own client, but thinking of the interests of the other side or of the other party for them to be able to reach an agreement. So in a collaborative practice, the parties and lawyers commit to negotiate towards an agreement using a problem and solving approach and a solution-focused approach so that they could move away from the courts. They focus on collaboration, trying to work out an agreement as parties who have a mutual interest, and they typically adopt an interest-based negotiation, which we recall from the book of Professor Roger Fisher and William Ury, looks at what are really the interests that underlie the legal positions or legal rights of certain parties. So, for example, a common example will be that if there were, you'll sometimes hear stories, for example, of parties who separate or divorce that they end up fighting over a casserole or even maybe an electric fan or whatever, just a single item. And it is because of that disagreement over the single object, or it could be a dog, that there is so much acrimony and hatred and anger between the parties. So now that legal position that I want that item can be couched in terms of a particular legal position. That's my right, I bought it, whatever. But sometimes there is actually an interest behind it. The interest might be that, that has a sentimental value to me. It brings up memories and so on. And it's important, therefore, in interest-based negotiation for a collaborative lawyer to try to unearth what these interests might be that underlie certain positions. It might be that I want to keep the house and, I'll pay you off or whatever. And the other party says, no, that's not the way it works. And then you ask, why are you interested in keeping the house? And, and it might be that he's probably thinking of, at some point I'm gonna be old. I may not have the money to buy this. I'm not really interested in having to go around and look for houses and so on. And so you see that a particular legal position has a lot of underlying interests behind it. And the job, therefore, of the lawyers and the participants would be to try to uncover these interests that underlie certain legal positions. In collaborative practice as well, all the parties, including the lawyers, agree to disclose all the information that they have. And the other thing we need to remember is that in the context of a collaborative practice, any discussions that we have are covered by usually a written agreement where there is confidentiality. So you can assume that anything that is divulged there will not end up being used in court, assuming that they are unsuccessful in trying to resolve their dispute. So there is an agreement among all the parties or participants to disclose all information and negotiate in a constructive manner. So you will already see that the approach to this collaborative practice is that there is a lot of good faith, spirit going into the effort. So where good faith is not there, where trust is not there, it's really difficult for the collaborative practice to work. But where parties agree that they would like to reach a settlement, they would like to avoid the dispute, or they want to do away with the dispute because they think they ought to be able to work together at some point despite the dispute, and they really want to avoid the courts. It is imperative for all the parties to think in terms of working together towards a solution. What can then happen is that the parties may ask a coach or a facilitator to assist the parties and their lawyers with communication. Almost in a sense, this is like a mediator, but this is different because the focus really of the coach is, just to coach them to try to, to talk and, communicate and explore options. The mediator's role is to really focus on trying to facilitate the discussion of the parties so that they end up resolving the conflict or resolving the dispute. The focus of the coach and the facilitator is to just get the parties to talk, not so much on reaching a settlement. The assumption of the coach and the facilitator is that by getting the parties to talk, freeing up all sources of communication, that will lead to a resolution of the dispute. The focus of the coach, therefore, is just teaching people how to communicate, teaching people to overcome, strong emotions, teaching people how to deal with, scenarios where it becomes a high-intensity conflict, even in the course of the discussions that they have towards a settlement. Okay, now, in addition, as I mentioned, because the parties, including the lawyers, are interested in trying to reach an agreement and avoid going to the courts, and there is the idea that people have to go there, have to enter into this particular process in good faith, and they must be willing to open up and divulge information. It is important and imperative that the parties enter into a written participation agreement. In many cases, as I mentioned, apart from the fact that the participation agreement will contain a confidentiality agreement so that anything that is discussed there cannot be used by any of the parties or any of the participants in any court proceeding. One of the requirements is that the lawyers who are involved in the collaborative practice and the lawyer experts as well agree that in the event the dispute is not resolved and then they have to go to court, or they have to take steps to commence legal proceedings, they will not be involved at all. They cannot be involved. They have to withdraw. They are disqualified. So what this means is that because of the disqualification aspect, a lawyer who is representing a client knows that if the dispute is not resolved through collaborative practice, that is the end of his or her legal engagement anyway. And so it's not like if a lawyer provides legal advice to a client, what some lawyers tend to do is to think that it will be good if this dispute is resolved and then legal proceedings are commenced, because a lawyer can then make more money in terms of billable hours as the court case progresses. Now, but in the case of collaborative practice, the lawyers involved in the collaborative practice know that if the dispute were not resolved and it had to go to court, they're not going to be involved anyway. They're not going to be able to bill their client. And so therefore, that in terms of the outcomes and then the way that they are able to bill for their practice and their services, it is limited only to that time when they engage in collaborative practice. The agreement typically also sets out that while the process is ongoing, there will be no court proceedings. It can also happen that because the focus is on really finding a solution and a resolution of the dispute, the parties may adopt a multidisciplinary approach. And it may be possible that in terms of getting experts to come on board to provide advice on how to get the interests resolved, or in terms of how to settle a dispute, they may invite accountants, counselors, social workers, or even psychologists. Now, for those lawyers, therefore, who are involved in this practice as collaborative lawyers, they have a different training where they should be trained differently, in the sense that when they speak of client representation, they have to think in terms of not just their client, the client paying them, but really thinking that they're actually representing both clients, in the sense that both clients have agreed, and all the parties have agreed, to try to find a solution to the dispute. And collaborative lawyers must also be familiar with negotiation principles and practices, particularly interest-based negotiation, and must have special skills in relation to problem solving that goes beyond providing solutions to problems based on the law. What this also means is that lawyers move from an adversarial viewpoint to a practice that is more cooperative, that looks at reaching a solution that is mutually good for all the parties. From a lawyer-directed rights-based negotiation, the focus of these lawyers engaged in collaborative practice would also be client-centered and interest-based negotiations. Collaborative practice can be used in civil and commercial disputes. They've also been used actually in terms of family law matters, in terms of resolving both the financial and parenting aspects of a family law matter. Now, in addition to collaborative practice, there are other alternative dispute resolution processes. Some of these are early neutral evaluation. You can also have case appraisal, either by the courts or by the administrative or in the Administrative Appeals Tribunal. You can also have expert appraisal, expert determination, as well as adjudication. So you will notice that this is a different set of ADR processes because it involves an appraisal, an evaluation, or in certain cases, a determination, almost close to an adjudication, or providing a decision on a dispute. When we talked about collaborative practice earlier, it wasn't about an appraisal, it wasn't about an evaluation, it wasn't about any determination or adjudication. Collaborative practice simply focused on the process by which the parties engage to reach a solution. You might even say that there is no evaluation there. No one there really evaluates whether somebody's right or wrong, whether the interests expressed by a party are correct or not, or what the law might be. The focus is to just look for a mutually acceptable solution for all the parties. But here, when you speak of appraisals and determinations, there are aspects of evaluations as well as determinations. Let's look at them in turn. When we speak of early neutral evaluation, we notice the focus there should be early, which means that before going to that point where the parties are in a full-blown dispute and are about to go to court, what they want to do is, okay, hang on, let's stop this for a while. If we have a dispute, why don't we give this to somebody for an early neutral evaluation? So it's almost like if you have two children who are fighting with each other, they might say, oh, okay, we can't agree with each other about this. Why don't we ask mom, or why don't we ask dad to evaluate what's going on and give a suggestion and tell us who might be right or who might be wrong. That is almost the way that the early neutral evaluation works. The participants to a dispute at an early stage in an attempt to resolve the dispute, they probably would provide arguments and evidence to a dispute resolution practitioner. When I say evidence, it's not evidence in the sense that there has to be a hearing or there has to be a trial. It's just providing enough information to a dispute resolution practitioner involved in early neutral evaluation to know what the relevant facts are in relation to the dispute. The practitioner then decides or makes a statement of the key issues in dispute, identifies what the key issues might be, and makes a suggestion on the effective means of resolving the dispute without really making a determination on the facts of the dispute. So when I say making a determination of the facts, the early neutral evaluator really tries to avoid making a conclusive statement on what it thinks are the facts in dispute, because to a great extent, it's really just providing an initial evaluation. So in other words, there is the evidence available is not really full, but on the basis of the evidence available to an early neutral evaluator, he or she is in a position to provide a first-hand view or an early view as to what the issues might be, as to what the issues in dispute might be, and moving forward, how a solution to the dispute might be possible. The evaluator's role might also include assessing the relative strengths and weaknesses of each party's case and offering an opinion as to the likely outcome of the proceedings, including any likely findings of liability or the award of compensation. You will notice the use of the word opinion rather than a determination or a conclusion. So the early neutral evaluator provides an opinion. This is my view. That, in a sense, is distinct from conciliation, you will remember, because the conciliator, when we discussed this in week 6, has an advisory role as well. But that advisory role is different because, almost in a sense, when the conciliator states a position as to what they think, provides advice as to what the respective legal positions are of the parties, you might say that advice is more than just an opinion. It's really an advice based on an expert view of what the law is based on the evidence presented by the parties. Here, in early neutral evaluation, because the parties really don't provide evidence in the sense that the early neutral evaluator is able to have full and complete information, because otherwise, in order to do that, there might be a requirement for the parties to make tentative statements and allow parties to cross-examine one of the parties or ask questions and so on. The purpose here is just an early neutral temporary evaluation. The statements made by the early neutral evaluation are really couched in terms of an opinion, and they're really provisional in the sense that it's subject to the provision that it can change depending on what the evidence might really be if it had to go to trial. In any event, it is helpful because at an early stage, people get a reality check. It's almost like, okay, they get an opinion from somebody who knows something, that these are our issues and this is the law and this is likely what will happen if it went to trial. So that, in a sense, provides an important reality check. The other alternative dispute resolution we should consider is what is known as case appraisal. Case appraisals are used in Queensland courts. It's also used in the Administrative Appeals Tribunal. And if you look at the case appraisal system, which is available in the Queensland government courts website, what happens is that the case appraiser meets with both parties to decide how the appraisal will progress. The case appraiser may ask parties to deliver witness statements and submissions before conducting a hearing. So you'll notice that the case appraisal here is now different because there is a hearing. When you talk about early neutral evaluator, for example, we didn't talk about a hearing, which is why the opinion, in a sense, the conclusion of the early neutral evaluator was couched as an opinion because of the absence of full information or evidence. Here in case appraisal, the case appraiser can conduct a hearing. The case appraiser may also read the documents sent by the parties and listen to the case presented by the parties from their lawyers The case appraiser assesses the merits of each case and makes a decision about the dispute, puts the decision in writing, and files a certificate with the registrar with a copy of the decision. So that's case appraisal in Queensland court. So what typically happens in case appraisal is that the court orders that, again, to minimize the backlog in the court system, appoints or refers a particular matter to a case appraisal, to a case appraiser. In the AAT, or the Administrative Appeals Tribunal, which reviews decisions made by administrative agencies. So, for example, if you have a decision is made by the Australian Taxation Office, or it could be by Centrelink, or a decision is made by the Immigration Department, any of those decisions, because they come from the executive agency, can often be reviewed by the Administrative Appeals Tribunal. But that is only because the statute that created those administrative agencies provided that the decisions made by the original decision makers of these administrative agencies can be reviewed by the Administrative Appeals Tribunal. So the Administrative Appeals Tribunal, by its nature, is a tribunal. It reviews the decision, the original decision of the original decision maker, both on a question of fact as well as on a question of law. And in the AAT, the AAT steps in the shoes of the original decision maker, so that when the AAT makes a decision, the AAT is in a position to actually vary or change the decision of the original decision maker, or substitute its own decision, or affirm it, or reverse it, or set it aside. But the point there is that when the AAT makes a decision, it is as if the AAT is making a decision for and in behalf of the original decision maker. But again, because of the many cases that come before the AAT, sometimes the AAT feels that it may require a case appraisal. The other thing we need to remember is that the AAT actually also has jurisdiction to review decisions made in relation to child support. And that's or it could be about refugees and so on. So that's a lot of cases dealt with by the AAT. So what the AAT does is to oftentimes use case appraisal as well. And when this happens, what happens is that there's an advisory process in which a tribunal member, officer of the tribunal, or another person appointed by the tribunal who has knowledge of the subject matter assists the parties to resolve the dispute. The appraiser provides a non-binding opinion of the facts and the likely outcomes. The opinion is an assessment of the facts in dispute, and the opinion may be the subject of a written report, which may be admissible at the hearing. So, for example, if there is a dispute between two parents pertaining to child support, so certainly it may be that one or both of them are not happy with a determination about child support from a child support reviewing officer, so they go to the AAT. But the AAT, instead of deciding on it and getting the parties to present evidence, they would instead perhaps refer it to a case appraiser. And the purpose there, again, is to form a non-binding opinion of the facts and the likely outcomes as a way of advising the parties that this is the way it looks if I were to appraise the case, and if this were to be submitted to a member of the tribunal, they are likely to form the view that this is the way that it will be resolved, and that will assist the parties to resolve the dispute by themselves. So they may agree, okay, we agree that this is the way that we would then resolve the dispute, and potentially on the basis of that agreement that they have, that becomes the basis of a tribunal decision on their dispute. So moving on, we talked about collaborative lawyering, collaborative practice. We talked about early neutral evaluation. We talked about case appraisal in the Queensland courts as well as in the AAT. And of course, case appraisal is not just in the Queensland courts. It can be in a lot of other courts, but in the example I gave, we just focused on the Queensland courts. Now, another alternative dispute resolution process is the expert appraisal. It's almost similar to the case appraisal, except that in the previous two examples we gave, these were cases either in the courts or in the tribunal, in which case it was the alternative appeal, it was the Administrative Appeals Tribunal. Here, it's still an appraisal, but it will be an appraisal by an expert. There is no case yet. So what then happens is that the parties submit their dispute to an expert appraiser who is chosen on the basis of his or her expert knowledge on the subject to investigate the dispute. The appraiser then provides advice on the facts and possible and desirable outcomes and the means whereby these may be achieved. But the statements or the opinions or the conclusions of the expert appraiser are generally not binding. The expert appraisal, of course, is a third party neutral. So the expert appraiser evaluates and appraises the dispute and the matter, looking at the law, looking at the evidence that are provided by the parties. So it should be clear that the appraiser does not act as an arbitrator. He doesn't make a determination. And because he doesn't make a determination, his statements are not binding, or his opinions or conclusions or his appraisals or evaluations are not binding, then he is not required to follow the rules of natural justice. Now, if the expert appraiser is meant to arrive at an appraisal or evaluation that is helpful to the parties in terms of them knowing what their respective legal positions will be and how things may turn out if they were to commence legal proceedings, it's imperative that the expert appraiser be in a position to know all the facts. So here, what the expert appraiser might do is to ask the parties to present evidence as much as they want. So the appraiser may be inquisitorial, ask questions, to get the parties to provide as much as information so that the expert appraiser is in a position to provide an appraisal or an evaluation that is supported really by the evidence that is provided by the parties. But of course, the appraiser is not bound by the evidence presented by the parties, because at the end of the day, the appraiser makes a determination as to the relevance or importance of certain documents and information that is provided by the parties. And as I mentioned, because it's inquisitorial, it may be possible for the expert appraiser to try to get the information on his own by asking the parties directly or even seeking information from elsewhere. Now, typically then, you will notice in the court system, the court is not inquisitorial in the sense that if the judge or the court has certain questions and needs evidence on a particular factual question, that evidence must come from the parties. The judge can't, be calling an employer or calling somebody, or the court can't do that in order to get information, because that will be inquisitorial, and that will be a breach of the rules of natural justice, because if that were the case, then the parties wouldn't have been given an opportunity to be heard. But you will observe that in expert appraisal, because the appraiser may be inquisitorial, it may be possible for the expert appraiser to chase other potential witnesses or other sources of information, even without the knowledge of the parties who referred the matter of the dispute to the expert appraisal. The appraiser will do that in order to get as much information as he or she could in order to be able to arrive at a particular conclusion. There is no breach of the rules of natural justice, because, as we pointed out, the appraisal or evaluation or report of the expert appraisal does not bind the parties anyway, in general. The parties also in expert appraisal may limit the issues to be appraised and the evidence to be submitted. Okay, so moving on, let's talk about expert determination. So the emphasis now is determination, almost close to adjudication. So you leave it to the expert to make a decision as to the dispute between the parties. So here in expert determination, I'm going to talk about how different this is from arbitration and adjudication in a short while. But in expert determination, you have an expert to whom the participants present their evidence, present their arguments. And of course, in terms of the expert determination, again, this is a possible role for a dispute resolution practitioner. The expert chosen in expert determination is one who has expertise or specialist qualification experience on the subject matter, and then who makes a decision. The decision made by the expert in an expert determination proceeding is generally binding on the parties by contract. So in other words, Earlier, when we talk about expert appraisal, there might have been an agreement between the parties, and one of the agreement of the parties was that they simply wanted a third party to evaluate the respective legal positions of the parties based on available evidence and based on the law. But they were not going to be bound by any evaluation made by the expert appraiser. That was part of their agreement, of the written agreement. In an expert determination, the parties agree that they will submit their dispute to an expert, somebody who's involved in expert determination. That expert determination has certain powers, including to ask questions, to receive evidence, examine the law, etc., and then make a determination or an adjudication about the dispute. And when that expert then makes a determination, the parties agree that they will be bound by that determination. So they are bound. That they're being bound is because of the contract that they entered into, that they agree that when they submit it to somebody who makes a determination about the dispute, they will be bound by that determination that is made. Okay, now, how is this different from arbitration? It's different. It's similar to arbitration in the sense that when the arbitrator makes a determination or arrives at a decision, it is binding on the parties. Here in expert determination, when the one involved in expert determination or the expert makes a decision or makes a determination, it also binds the parties. So they're the same in that sense. They're also the same in that sense that both the adjudicator as well as the expert involved in expert determination examines the law, examines the evidence provided by the parties. They're similar as well in that sense. They are different for several reasons. If you speak of arbitration, the reason why the parties go to arbitration is that when they, for example, enter into a written agreement to refer a dispute to an arbitrator, they do so, but that is within the context of the Uniform Commercial Arbitration Acts of the various states. So they may simply say in a written document that in the event of a dispute over a commercial transaction, the parties will refer the dispute to arbitration. That's simple. And on that basis, it will now be the Uniform Commercial Arbitration Acts of the various states that will govern how that arbitration will take place. So under the Uniform Commercial Arbitration Acts, what then happens is that there are strict formalities that have to be followed, rules about how arbitrators are chosen, what the powers of the arbitrators are, etc. That is governed by the Uniform Commercial Arbitration Acts. Okay, so UCCA. When you speak of expert determination, this is different because the so-called powers of the expert involved in expert determination is actually set by agreement of the parties. So the parties in their contract decide what the powers are of the expert involved in expert determination. There is a difference as well in terms of the formalities that are used. The parties can potentially, make use of, have some ideas about how to choose the expert in the expert determination, but here it's relatively up to the parties to determine, how to choose an expert and so on. There is some similarity as well in the sense that because you're dealing with an expert, somebody involved in expert determination, typically the rules of natural justice will have to apply, in the sense that the one who is involved in as an expert in expert determination has to observe the rules of natural justice. He must provide all the parties involved an opportunity to be heard, and the expert must be one who is objective and impartial, not only in terms of an absence of an actual bias, but there should be no apprehension of bias as well by any of the parties in terms of the conduct and communication made by the expert in expert determination. Okay, now let's talk about adjudication. This particular ADR process is quite common in the building and construction industry, where there can be a dispute as to payment. for example, payments for goods and services under a construction contract. So for example, in Queensland, you have the Queensland Building and Construction Commission, which has been created under a Queensland statute. There are equivalent or similar statutes in the ACT, New South Wales of Australia, and so on. And in the case of adjudication in relation to building and construction contracts, the role of the adjudicator in that sense is to help resolve the disagreements between the parties about progress payments and the monies owed. It is a quick and cost-effective alternative to having to go to the court. So this is by statute, okay? And so when the parties are in dispute about an amount owed for construction work, for example, the claimant can lodge an adjudication application with the registrar of the Queensland Building and Construction Commission. The registrar will then refer the application to an adjudicator to make a decision about the disputed payment claim. The participants present arguments and evidence to a dispute resolution practitioner who is appointed as the adjudicator, who makes a determination which is enforceable by the authority of the adjudicator. And under statutes, the decision of the adjudicator is enforceable in court, and it is an offense for the respondent not to pay an adjudicated amount before the due date. The Queensland Building and Construction Commission may also take disciplinary action. So there is adjudication here. There is also scope for a hearing, but this is governed not, unlike arbitration, for example, which is governed by the Uniform Commercial Arbitration Acts. In adjudication, it will be governed by the relevant statute, for example, that created the Queensland Building and Construction Commission. Okay. Finally, let's talk of two other ADR processes. We'll talk about court-appointed referees, and we'll talk about restorative justice. When a proceeding, legal proceeding has already been commenced in court, it can also happen that a court may decide to refer a particular dispute to a referee. So that will be a court-appointed referee. The parties themselves can also ask the court to appoint a referee to decide a specific issue. This might be because the issue to be decided is one that requires an expert, and it may be an expertise that the judge does not have, or will require a lot of time to go through. And so in order for the court not to have to spend too much time on some intricate or complex issues relating to a legal matter, it might often be the case that it is preferable for a court to appoint a referee. It might be because the complex matter might refer to, let's say, biotechnology or some intellectual property issue or the valuation of a property and so on. And given the very complex nature of a particular legal matter, the court feels that it may be better to just refer that particular issue or issues to a court-appointed referee. That referee then, that is appointed by the court, can hear arguments from the parties, and then that referee will hand down a report that sets out the arguments in brief, together with the legal reasoning behind the referee's decision. Now, each Australian jurisdiction has a system of referring disputes or parts of a dispute to a court appointed referee. For example, the Uniform Civil Procedures Rules of 1999 Queensland under Section 501. The court orders for referees do not require the consent of the parties. It may be that the court, in the exercise of its inherent jurisdiction, decides or makes a decision to refer a particular matter or a dispute, or the determination of a dispute or an issue, to a particular referee. And well, as I mentioned, we'll usually have a specific area of expertise. If you look at Section 501 of the Uniform Civil Procedure Rules of Queensland, the court may refer a question to referee. The court may, at any stage of a proceeding, make an order referring a question in the proceeding to a referee to conduct an inquiry into the question and prepare a report, or the referee's report, to the court in question. However, the court may not make an order under Sub-Rule 1 in relation to a question that is required to be tried by a jury. So if there's a requirement that it is a legal matter that has to be tried by a jury, then Section 501(1) doesn't apply, and the court in that case cannot refer the matter to a referee. But if the court issues an order referring a matter to a referee under sub-rule 1 of Section 501, an order must appoint a person as the referee for the question. It must state the question for the referee and must require the referee to decide the question or give the referee's opinion on the question, and may direct the referee to give further information in the referee's report as the court considers appropriate. Now, what are the advantages of the use of court-appointed referees? It frees up the judges to carry out their duties as judicial officers. They can, make better use of resources that benefit the community. So some of the functions, especially about, fact-finding and determination of complex issues, can then be relegated or delegated to an expert on the subject rather than making use of the court's time, especially when there's a huge backlog that might be, plugging the court system. It allows other people with technical expertise to be involved, and it will allow a high technical standard of evidence to be presented and considered by an expert. Because certainly, there are limits to what a court can do. For example, questions about inventions that have been made, and a small change in an invention, the question then becomes who owned that invention, also the intellectual property over it, whether it's about medicine or some innovation. Sometimes it's better for the court to give this task over to an expert on the subject. Okay, so finally, we're going to be talking about about restorative justice. And before we talk about restorative justice, for example, I want to highlight that when you speak of restorative justice, for example, it doesn't usually fall within the usual conception of a dispute, because restorative justice is often considered as an alternative dispute resolution process. But it begs the question, if there, in relation to restorative justice, which focuses on the criminal justice system, if there is a crime, is there really a dispute? When you consider a dispute, when we have considered disputes at the past few weeks, we look at a dispute as involving a disagreement or an argument between parties, or several parties. But it's in that case where there is a dispute or an agreement, both parties actually disagree, and they may have certain respective rights and so on. I also highlighted in our discussion about conciliation that there's another different dispute, and we're not sure if it's really a dispute. For example, when you have an aggrieved party because somebody is aggrieved or has complained that he has been discriminated against, or there is a violation of human rights, or he has been subjected to unfair dismissal, it's difficult to say that there is a disagreement or that there is an argument. You can simply say that there is an aggrieved there. And it's difficult to characterize that kind of situation as having being involving a dispute. You do have a situation where one party is certainly aggrieved. Okay, and I would suggest that when you speak of restorative justice, it's difficult also to really say that when you speak of restorative justice, it's about the use of restorative justice as a way of resolving the dispute. Because if there is a crime, can you really say that there is a dispute? So when somebody has been assaulted, when somebody has been raped, when you have an offender who has committed a theft and so on, was there really a dispute? Some would say no, there's none. In any event, it's common to talk about restorative justice as an example of an alternative dispute resolution process. So we're gonna examine that. But again, take note that for a lot of people or commentators, they wouldn't consider restorative justice formally as part of the ADR process, mainly because the fact that there's a crime means that there is really no dispute in the usual sense of the word. But let's examine restorative justice. So when you speak of restorative justice, it's commonly used in the criminal justice system. It's a way to steer away the offender from the formal criminal justice system. So instead of the offender going through the formal process of either being tried by a jury or a trial being really presided over by the judge, and the judge makes a decision on the basis of the law and on the basis of the evidence. This is different because in restorative justice, the goal is to try to go beyond the law. And there is a component that speaks of the commission of a crime, not as one which requires a punishment of the offender, but also as a way to try to restore some sense of justice to the victim, and at the same time hoping that on the basis of this process, the offender will change and will less likely become a recidivist or one who becomes a habitual offender. A restorative justice process will often encourage a meeting, what is sometimes known as the victim-offender conferencing, between the offender and the victim and others affected by the offense, family members, and other support people to discuss the offense and its impact. The crucial point here is that the offender has to be there, but as we will see, sometimes you can have restorative justice without the victim being there. But the crucial point is the offender has to be there in a restorative justice meeting. The practitioner who facilitates the conference may be part of the criminal justice system, for example, a police or corrections officer, or an independent person. It can include diversion from court prosecution, actions taken in parallel with court decisions, and meetings between victims and offenders at any stage of the criminal process. We would have heard a lot of restorative justice in the papers today, where sometimes we have youthful offenders who sometimes get a slap on the wrist or just end up not being prosecuted at all for as long as they go through the restorative justice process. Now, whether or not we think it is something that is laudable, well, that's an open question. And whether or not we think that the results are good, that's something we're going to be examining next. So the process about restorative justice emerged mainly because there was a perception that there was a lack of concern for the victim's rights. We need to remember that when you speak of a crime, the character of that crime is actually one that is considered public in nature. So if it's a crime, it's not, criminal law doesn't look at the criminal action as an offense against the victim. It's really an offense against the state. So it's an offense against the regina, or it's an offense against the people. It's not an offense against the offender. That is the characterization of criminal law. And so because of that, the focus is not so much really about the rights of the victim. The focus is on the offense to the state. And oftentimes, therefore, in the traditional criminal justice system, the rights of victims, the voices of victims are hardly ever heard. They're not given much value. We're not really not given much value, but they're not at a premium. Oftentimes, you might even say that the focus of the criminal justice system, for the purpose of ensuring that there is a fair trial, really focuses on the rights of the offender more than the rights of the victim. So that was that's some of the conceptions about the limitations of the traditional or the conventional criminal justice system. There was also the other concern that incarceration rates were too high. If the focus is on punishment, and there are just so many rule breakers in society, so many criminals, so-called criminals, so many potential offenders. If every time a crime is committed, we incarcerate them, we imprison them, then there are just too many people who are being imprisoned. And some would complain that sometimes, as far as incarceration rates are concerned, these incarceration rates are disproportionately against certain sectors of society. For example, it may be a lot of the offending, based on reports, may be committed by indigenous people, and it might be that if you just focus on the punishment, it may be that the focus on punishing people for crimes fails to account for the fact that a lot of these crimes are actually situational, in the sense that maybe there might be some underlying problems about justice and poverty that lead certain people to commit crimes. And so therefore, the solution, if you want to bring down crimes, for example, the solution is not to punish, but the solution is to try to resolve those causes or those problems that lead people to commit crimes. So that's again one of the overarching reasons for the principle of restorative justice. The other reason was that there's also evidence, also in Australia, very high rates of reoffending. In other words, even if you incarcerate people, especially the youthful offenders, by the time these youthful offenders are freed, from prisons, they are likely to be hardened criminals. They may become institutionalized in the sense that for some people, they probably feel more comfortable being in jail because that's what they're used to, rather than being out there in civic society where people are expected to follow certain rules. So that, in a sense, incarceration and punishment really doesn't minimize or lower the risk of reoffending. So that was one of the concerns. And it might be because for a lot of people, and this is going to be part of the discussion we're going to have when we talk about restorative justice, in many cases, when we talk about an offense, it is possible that an offender, for example, who commits a crime, fails to see the victim of the crime as a person and really just looks at the victim as an object. So in other words, when somebody commits a crime, well, it's just a crime, he or she may not think about the impact on the victim. He or she may not think about the turmoil and the misery that a victim has. The offender doesn't see that, doesn't feel that. He doesn't have to feel that. Sometimes you may, especially for men, sometimes men might say, and I'm not saying that men commit crimes, but when men may commit things that are harmful towards other human beings, sometimes men may prefer to be punished. Just hit me or shout at me or scold me and so on. That's fine, that's punishment. But if a man is exposed to a woman, for example, and I'm not saying it happens all the time, but for a lot of men, if they'd rather feel the physical pain rather than the emotional pain of seeing somebody being hurt, of a woman crying, okay? And that's a problem with the traditional criminal justice system, because the focus is on the physical aspect of incarceration and punishment, but there is an absence of a concern or articulation or demonstration about the emotional costs, not only to the victim, but to the victim's families as well. The other motivation for the restorative justice principle is that the accountability is in line with religious and moral theory. It fits with community thinking that when you speak of restorative justice, you go beyond the law, but you talk about religious practices and moral theory. So therefore, if you think in terms of a crime as involving human beings with certain religious principles and norms that underpin their behavior and the expectations of society, then it is consistent with religious and moral theory. Okay, so going back, when you speak about restorative justice, as I mentioned, a crime is not just against a state, it is also more clearly against individual victims and the community. So in restorative justice, the goal is to give a victim a voice. The victim must be heard. This goes beyond the traditional impact statement of a victim, because when you have an impact statement, for example, that is made by a victim to a court, that impact statement traditionally is really for the purpose of moving a judge, perhaps to issue a harsher sentence against an offender, or maybe a more lenient sentence. But in a traditional victim impact statement in a criminal justice system, the impact statement is addressed more to the court rather than the offender. In restorative justice, if there is an impact statement made by the offender, because it is outside of the court proceedings, it is really directed to the offender so that the offender becomes aware of the emotional and physical costs to the victim and the family members of the victim. So that the goal then is for the offender to be accountable and to make amends. So it's not just about punishing the offender. It's easy for somebody to be punished, but to make amends, to make corrections, to make the necessary changes in order to restore justice, that is something else. It's almost like if somebody were to steal money from an employer, let's say $200,000 has been stolen by an employee, yes, the employee will be punished. But if the employer has not been repaid the money of $200,000 which was stolen, there is still no justice. And so therefore, the goal of restorative justice is for the offender to possibly make amends. Now, the question though, so the idea there is that by using restorative justice, the offender becomes more aware of the consequences of his actions. The offender begins to see the victim not just an object without any feelings, but for the offender to see the victim as a human being with feelings and with a future and so on. And the question, and so by doing so, by opening up the offender to the broader dimensions of the impact and consequences of a crime, the idea is that the offender is moved. He might become more remorseful. He might really feel the consequences of his actions. He might say, "I didn't know that was the, this was the impact of what I did." When you see this, for example, when you see these stories of terrorists and killing lots of people, or psychopaths who kill a lot of people, you might really form the view that to them, when they commit these crimes, surely they can't think of a human being as a human being. To them, it's just it's just an object, right? And the goal, therefore, of restorative justice is to make the offender see that his actions, which constitute a crime, impact a human being. But the question then is this true? By making the offender see the broader dimensions of a crime and its impact on a victim, and that the victim is a human being, is it really true that it leads to a reduction in crimes? Is it really true that it leads to a reduction in recidivist behavior or reoffending? The results, however, are pretty mixed. There are some which suggest that it can reduce crime rates and recidivist behavior, but the results are mixed. In some cases, there is little evidence to support the belief that restorative justice will lead to a reduction of crime rates, nor that it will discourage reoffending. I'm not going to go into the results of the research on that. Restorative justice is also able to account for cultural, religious, ethnic differences and diversity by considering the background of the offender as well as the victims. And restorative justice is intended to give a deeper understanding of what is needed to reintegrate an offender into a community, and hence a greater understanding of what resources are needed. So instead of just focusing on punishing the offender, it may be that in order to minimize the chances of an offender reoffending, and in order to reduce crime rates, restorative justice falls into the bigger criminal justice system view that there should be options given to offenders, consider drug rehabilitation and youth support groups, etc. Now, the question is, as I mentioned, is restorative justice, a good solution in relation to the criminal justice system? The evidence, as I mentioned, is already mixed, and all is not really well. Sometimes there is the view from the public that offenders tend to be treated too lightly, so they get away with it. So in other words, if you have an offender who goes through the restorative justice system, some of them may just fake it. They may appear to listen, blah blah blah, but actually they do it to game the system. And because they participated in the restorative justice system, the courts may then, or the magistrates may then say, "Oh, okay, so I see remorse in this offender, and so therefore, instead of imprisonment, you're just gonna be, this offender will just go out on a good behavior bond, or without even any convictions recorded." So it's possible that the view that offenders are treated too lightly, and in that particular case, it causes problems for victims, because they think that there hasn't really been much justice, in the sense that there has been retribution or punishment. And if you look at it from the context of problems in Queensland, for example, where there's a lot of youth crime going on, you know, youths going into homes to steal stuff, or to commit robbery, engage in violent crime, and so on. And there's a huge number, given the crime problem in Queensland in relation to youths. You begin to wonder whether or not restorative justice is a solution. And I don't have a view here because I'm not an expert on the subject, but it is an open question. It is open to debate whether or not these types of offenders should really be treated lightly, or they should just be locked up because they are a menace or threats to society. Some also form the view that, as I mentioned, there are inconsistent and different outcomes. But the other aspect is that by going through the restorative justice system, although the victims don't necessarily have to participate in the restorative justice system, because the focus really equally is on the offender, there is a possibility that there is, in a sense, the re-victimization of the victim by forcing the victim to have to be involved in the process or be aware that there is a restorative justice system that is going on. That is something that the victim may not be happy with. And the victim might think that, okay, you're treating the offender with kid gloves, you're treating the offender with mercy, but how about me? So that's another problem. And as I mentioned, when you think about restorative justice, is there really a dispute? Because it's not so much like a dispute between parties. You really have an offender who has a victim. So while ADR is often restricted to consideration of the interests of parties to the relevant dispute, the criminal justice involves consideration of a number of public policy goals as well, such as punishment, deterrence, protection of the community, and rehabilitation. So that's one way why, when you look at restorative justice as potentially not really being part of the usual alternative dispute resolution processes, the reason for that is that the focus of ADR is really to resolve a dispute between parties. When you speak of restorative justice in the criminal justice system, it has more broader goals, avoiding punishment, looking at deterrence, protection of the community, rehabilitation, justice, and so on, which are not traditional goals of ADR, because the goal of ADR is at its core is simply to resolve the dispute. Okay, now in Australia, as far as restorative justice is concerned, it is actually mainstream for juvenile offenders, and it has largely come in the form of conferencing, which includes forum sentencing, circle sentencing, and victim offender mediation. Conferencing is available in each state in Australia and territory of Australia. In all jurisdictions other than the ACT, the conference can take place without the victim's participation. Conferencing is also available for adult offenders in certain circumstances. So if it's typically if it's a minor crime, a property crime, then restorative justice and victim offender mediations or conferences would probably work or have been considered, but not in relation to serious crimes. Pilot programs for adult conferencing have also been undertaken in other jurisdictions. And so with that, after completing this topic, you should now be able to discuss and explain the several additional ADR processes, the collaborative law and restorative justice, as well as any relevant theory, decided law, and or practical skills relating to ADR practitioners. And with that, I thank you for watching this lecture video. Bye.